The ruling is in, and a federal court judge has decided that Virginia does not have to turn over its voter registration list to the U.S. government. A federal judge has dismissed the U.S. government's lawsuit against the Commissioner of Virginia Department of Elections with prejudice, meaning the case cannot be revived. U.S. District Court Judge Roderick C. Young found the federal government's complaint contained defects that cannot be cured. The dispute began back in July 2025 when the U.S. Attorney General requested that then Virginia Elections Commissioner Susan Beals, who was serving under the Governor Glenn Youngkin administration, turn over the state's full computerized voter registration list. That request included names, dates of birth, addresses, driver's license numbers, and even the last 4 digits of voters' social security numbers. The stated purpose for wanting that list was to review compliance with federal election law. According to the federal government, discussions continued in the months afterwards, but by January 2026, representatives from Commissioner Beals' office informed the Department of Justice in person that Virginia would not be providing the voter registration list. Roughly a week later, the U.S. government filed a lawsuit. After Governor Abigail Spanberger took office later that same month, the lawsuit was amended to name her new elections commissioner, Stephen Koski. After being named in the lawsuit, Koski argued the federal government's amended complaint failed on several fronts. First, Virginia's statewide voter list isn't the type of election record that states have to make available under federal Title III. Second, Virginia argued the Attorney General never provided a factual basis for demanding the list. And third, Virginia argued the stated purpose for the request was contrived and legally insufficient. Ultimately, Judge Young agreed, calling the arguments persuasive and dispositive. He ruled that Virginia's voter registration list falls outside of the scope of Title III of the Civil Rights Act, meaning the federal government failed to state a valid claim. Judge Young noted that under the Help America Vote Act, which the U.S. government cited in its arguments, state election officials retain discretion over the appropriate method for creating, for storing, and for maintaining the voter registration list. Judge Young found that federal law simply does not require Virginia to hand over any unredacted voter list. He concluded that no amendment the U.S. government could make would fix the defects in its complaint. Virginia's motions to dismiss were granted, and the court deemed that its ruling was fatal to the U.S. government's case. After the ruling, Virginia Attorney General Jay Jones issued a sharply worded statement in which he said, quote, Donald Trump, Todd Blanche, and Harmeet Jillian tried to seize Virginia's voter data through what we successfully argued was a contrived demand with no basis in law. The court saw through the ploy and rejected their attempt to attack our electoral system. We are proud of the secure, professional way elections are run in Virginia and grateful to the attorneys in the Office of the Attorney General whose work stopped Trump's partisan operatives from dragging our system into their campaign of chaos and distrust.